Thank you, Mr. Chairman, members of the Commission. My name is David Lutter. I'm here today to speak on behalf of the Environmental Defense Alliance, but I do want to make a side comment first. I represented a number of black residents of Alabama on one of those Title VI challenges that Director LaFleur mentioned. If all you know is what he told you today, you do not have the full story. And I will come back to this commission next time and give you the rest of the story. But on behalf of the Environmental Defense Alliance, I'd like today to talk about encouraging this commission to adopt some policies or rules governing how you conduct business over email. I came before you in August and at that time made a presentation where I suggested that the use of private email services to communicate with others about official business and the failure to disclose those emails must end. I believe that was subsequent to the conviction of Oliver Robinson, David Robertson, and Joel Gilbert in July over the North Birmingham situation. Part of the reason that I came before you in August was because a lot of the records that were disclosed in the trial of those defendants showed email traffic that occurred between a former AEMC member, Scott Phillips. On September 27, 2018, the president of the Environmental Defense Alliance wrote this commission that in the wake of the testimony and convictions in that case I just mentioned, public confidence in this commission and the department has been severely shaken and perhaps irreparably. We suggested that drastic measures must be taken by the commission to restore public confidence, and we submitted detailed recommendations. One of those was to end the AEMC practice of conducting public business on private email. At the October meeting of this commission, board member Mark Johnston made a presentation where he again recommended that the AEMC end the practice of conducting public business on private email. None of those requests and the recommendations have been responded to by this commission. The records introduced in the trial of Gilbert and Robertson show that during his tenure on the commission, Scott Phillips sent at least 23 emails to persons representing Drummond Company concerning the 35th Avenue site in North Birmingham. That he received at least 27 emails from persons representing Drummond Company concerning the 35th Avenue site. A public records request was submitted to the AEMC on July 23, 2018. The response that we got did not include any of these emails that Scott Phillips either authored or received. As a consequence, we have these recommendations. Assign all EMC members an email address on the domain adem.alabama.gov. That would be a government managed email system, and require that the EMC members use it for all AEMC and ADEM related business. In other words, cease using private emails. Second recommendation is require that all emails sent or received by EMC members concerning EMC and ADEM related matters, regardless of domain, be copied to the EMC executive assistant. That would put emails that originate from whatever source but are related to government business in the hands of a government official, the AEMC executive assistant. And the third recommendation is to make all past and future emails sent or received by EMC members concerning the EMC or ADEM related matters, regardless of the domain used, that is, regardless of whether you use a private email server or a government server, make those emails available to the public upon request. Obviously, my position is, and the position of the Environmental Defense Alliance is, that if you're doing government business, the government should have a right to look at what you're doing. 4 easy steps to get where we want to see you go. First, one of you has to make a motion to adopt recommendations as policy of the EMC. Second, a second EMC member has to second the motion. You all know this process. You all know how to get there. Third, you can discuss the motion. And fourth, you vote on the motion, up or down. But we haven't heard from you since August. We'd like one of you to make a motion and to get this process started. At least have a discussion about it. Don't go month after month with no discussion. We await your action. Thank you.
I was calling Robert Tambling, our attorney from the Attorney General's office, to please comment on whether the Open Records Act or the Environmental Management Act allows for either a policy or a rule regarding this situation.
Well, good morning, Commission members. I personally, as your lawyer, have serious reservations whether the Commission may lawfully adopt this proposal as a rule, regulation, or even as its own internal procedure. It's fairly well settled law in this state that an administrative agency is a creation of the legislature and only has those powers conferred on it by the legislature. So an agency like the Environmental Management Commission cannot just adopt rules or fabricate policies out of whole cloth. There has to be some underlying statutory basis or legal authority for doing so. Whether you're talking about a rule, a policy, or an internal procedure. So while an agency like the Commission might have the inherent authority, for instance, to adopt policies in order to manage and conduct its own business meetings, I'm not aware of any statutes or other legal authority that would authorize an agency in any way to restrict or regulate how its members are allowed to use their own private personal email accounts. So for that reason alone, I would recommend that the Commission not take any action on this proposal. I think Mr. Lutter's best recourse would be to take this matter up with the legislature and have them pass a law requiring it if they so desire.
Are you aware of any state agency that requires a .gov or .state email address?
For boards and commission members.
For boards and commission members, I'm not. I haven't done an exhaustive search, but I'm not aware of it now.
Okay. So I guess the answer, Mr. Lutter, would be go to the legislature and get them to pass it.
Mr. Chairman, obviously the department operates an email system for its employees. And I'm sure the department doesn't allow its employees to use private emails for government business. If they do, certainly is inappropriate. So if the department can do it, I don't see why you can't do it. You, the commission, are part of the department.
Thank you for your comment.
Do you know, Mr. Letter, of any other
I haven't looked.
state agency? I mean, I have other friends on various boards and commissioners now and in the past, and they all use their work or home email address. So, to my,
If that's going to be the rule in the state of Alabama, then we're just going to have to sue the commission members to produce emails, public records, that are maintained in your possession. Something
Well,
we'd rather not do.
I think the overwhelming majority of email traffic among the commission members does copy Debbie or Director LaFleur, because it is usually an email that they send that generates the discussions. If you send letters, you send them to Debbie, then she sends them to us. So they're usually copied, and you used the example of former Commissioner Scott Phillips, and I don't think you suffer any illusion that if we had had this email address or this policy in those email with the folks in that trial, that he would have used his .gov email address.
Well, wouldn't it have been nice if he had?
But do you think he would have?
I don't know. I don't know what his mind, what his intentions were. I mean, obviously, if he was intending to violate the law, then he wouldn't.
Well, of course, we don't know that he's violating the law until it's filed.
Exactly. We don't know what his intent was.
Exactly.
We do know he used an email address that wasn't a government email address.
And all of those, none of those came through the department because they looked for me. So what difference would it make?
Well, if they had come through the department, if you had a policy requiring them to come through the department, we would have the information.
Well, we just heard that we can't make that policy.
You heard one opinion.
Okay.
You did mention,
I'm sorry.
let me back up for a minute. Based on when I made reference to the Phillips email not be on a .gov email, it was based on, you sent what I call a tome of a summary to us of the trial, and it referenced some outside business that those folks were allegedly had with Mr. Phillips.
Right.
And whether it was with those folks or anybody else, that would be done, not be done on a .gov email, I guess was my point. Right?
I mean, if he has nefarious reasons for doing that, sure. If you had a government email, then at least those who choose to comply with the law would use it.
But if it was work related, not related to the commission business, it would not be on .gov.
Obviously, if it was work related, unrelated to commission activities, but his email was related to commission activities.
I haven't seen them all. I call it a tome of a summer because it was so long. There was something else I wanted to ask you.
Well,
Oh, I was going to point out that, during this process over the last year, you've made record requests, other people have made record requests. And Debbie forwards those to us to see if we have documents and email on our private email. I don't consider mine necessarily private since it's my law firm's email account. And we respond to those to the extent we've got anything. This second or other thing, I guess, I personally am concerned about is having one more email account, to check. My wife's already fussing at me because I don't check my personal email account where all of my anything related to the kids goes. I'm always asking her, and she's like, "Did you read the email?" No, I didn't. And I don't want to make light of it, but look what you're proposing. But it is a concern that my work email address is the best way for me to timely get information and respond to information because it's always in my pocket and it's always on.
Well, like I said, we recommended that the best alternative would be to create a ADEM email address that you all use for business, for ADEM business. If that's not possible, then every email that you send from a private email server should be sent to somebody at ADEM, copied to ADEM, so it becomes a public record and people can access it.
And I think that is our normal practice,
That's the
is
most
that,
I've
is that we copy heavy on most everything, on everything.
Well, it's the most everything that
Yeah.
bothers us.
Well, nothing is 100%,
Well, this ought to be 100%. These are public records.
I've gotten email from, board members that you represent here today that, didn't go through Debbie, but I don't think there's anything nefarious about it.
Well, those should be public records. They should be accessible, and if they're in your email system, we're not sure we're going to get them. So that's why we say copy everything to Debbie automatically. Let me just close with these few comments. State law requires public officials to maintain public records and protect them. State law also requires that they be delivered up for examination on request. And it doesn't matter where they are, if they're public records, they are due to be delivered up. And it's a crime not to deliver them up. It's a misdemeanor punishable by a year in jail if you do not deliver them up after requested to do so. I would suggest that you ask the Attorney General for a formal opinion about the question of whether you have authority to adopt rules or procedures on the management of emails. I'll leave it there.
Thank you.
Thank you.
May I just make a point? I'd like to underscore
That
what...
you work for the Attorney General?
Yes, I do. But just to underscore, Commissioner Brown, what you said, and just to shed some light on what Mr. Lutter was talking about in his presentation. When Mr. Lutter makes a public records request, that public records request is circulated to all the commission members. And we ask and have asked all of commission members to search their emails for anything that's of ADEM related, EMC business related, that is a public record. And those are turned over to us, and the lawyers go through those, and we vet them to make sure, that they're subject to disclosure. And we feel like we've done our job in getting that done. So that's all I have to say about that.
I don't doubt the diligence of asking. It's what he gets in response to those asks. That's the issue.
Okay.
From what I can understand Robert is saying, you can make a request, but Robert and Kayla have to determine what you're allowed to receive from your request. So, a court asking for something is different than a citizen. So,
Well, I think it's, I think the difference is the email that Mr. Lutter is referring to with Commissioner Phillips were beyond the scope of a public records request. And I think that's why he's making the suggestions that he is today. But I think the bottom line is that The commission members, when we communicate by email, Debbie is copied. And when we do receive public records requests, we are asked to search our email and provide them. And I know I've done that. I presume that all of my colleagues up here have done the same. And I suspect and encourage everybody to continue to do that and to try to remember to copy Debbie.